A very good evening to all of you. So I can see we do have about 100 odd participants for the particular session. So on behalf of IDM Nations Campus, I warmly welcome all of you. This is our first segment after some time that we are running. We do started a series of webinars since January, but officially we are commencing from this month onwards a series of lecture series in the purview of IDM Nations Campus management and the Buckinghamshire University instructions, a series of law webinar series making an awareness about the particular important areas of law. This would be a social service as well. And in the meantime, an awareness program educating the lay people or the lay crowd as well as our student community of IDM Nations Campus. So this is an open invitation we have given to all the participants who have just joined. So I believe in the meantime, we would be having more participants to join. So going ahead with IDM Nations Campus, with me, I have a learned panelist who would be sharing their views and their thoughts and sharing their knowledge, more of all, with all of you. They are academics as well as the practitioners in the field of law. So with us, we have President Counsel, Sir Prasantha Lal De Alwis. Sir, we warmly welcome you for the session. And alongside, we have attorney at law, Gimhan Sooriyabandara. He would be the moderator for the session. So once I complete my introductory session, I would be handing over the session to Mr. Gimhan. So apart from Mr. Gimhan, we also have our gathering, the panelist who has joined with us with Prasantha, Mr. Bhadraka, attorney at law, who is also, I believe, have a versatile knowledge with regard to various aspects of law. And also with us, Mr. Nirmal Poornajith, also an attorney at law, and also Mr. Asel De Silva, a Moot court coach, who will be sharing their thoughts and their knowledge and their purview, the experience they have gathered with regard to the subject on fundamental rights. So talking about IDM Nations Campus, we've been in the industry of education for last 3 decades, but our law school have started performing since 2015 onwards. So we have produced law graduates to the community, and most of our students are now completing their attorney at law qualification in Sri Lanka Law College. And we do have practitioners as well who have come out from this Buckinghamshire University as LLB graduates. So we do have our alumni also joining with this particular program. So welcome all of you and the learned gathering. So I warmly welcome all of you and take part in this session, actively participate. Your questions and questions are welcome. You have a Q&A bar on this particular panel. So our panelists, as soon as they are done with their explanation, they are also invited to answer for the Q&As that you could view on this particular panel. Right. Thank you very much. I would like to ask Gimhan to take up from this onwards. Thank you.
Right. Hello, good evening. My name is Gimhan Sooriyabandara. So I will be your moderator for today for this event. And so as you know that today's session is going to be on fundamental rights. This is going to be a panel discussion on fundamental rights. We are going to discuss the status of fundamental rights and the importance of learning fundamental rights as students, right? Okay, so today, as Ms. Anushika introduced to you, that we have a very important panel of experts, like professionals, like they are like the best people that you can basically like ask for. So first of all, a big thank you to all of y'all for coming today to take part in this event as resource persons. Right. First of all, I'd like to remind you that today's session, we will be discussing on 4 main topics. We are going to discuss about defining fundamental rights, and then the status of fundamental rights in Sri Lanka. And lastly, we will be discussing the remedies we have available for fundamental rights in Sri Lanka. And other than that, we will also be focusing on the importance of learning fundamental rights as law students as well as general citizens. Right. First of all, the first question that we have is defining fundamental rights. Now, I believe some of y'all here would be like law students, or you may have a basic idea about like how fundamental rights work, what fundamental rights are, but we might have certain individuals here who would not be aware of that basic part. So we'll start off with that. First of all, I would like to focus our attention to defining fundamental rights and understanding what fundamental rights are. I would like to direct the question to the most senior and the most experienced panelist that we have for today, Mr. Prasantha Lal De Alwis, President's Counsel. He is one of my mentors, to be honest, actually one of my seniors. He was my lecturer of criminal law when I was in university, and my lecturer of evidence law when I was in law college. So I personally decided to invite you, sir, because I know that how good you are in explaining things, especially like, these kind of complex topics that you have the ability to, break it down to a very simple language. So for the benefit of our attendees today, sir, I would like to ask you, I would like to invite you. The question we have today is like defining fundamental rights and what fundamental rights are in simple language, and how important they are to us. Over to you, sir.
Can you hear me, Gimhan?
Yes, sir. Yes, sir. Audible and visible, sir.
Thanks. Good evening, everyone. This is a very interesting topic, fundamental rights, as Gimhan pointed out. It's something that you and I all have. Now, if it is criminal law, if it is delict, if it is contract, any one of us, or law of property, it is something which is basically, if you have an issue only, we have to go for that. If you want a divorce, then you go to law of persons. But every one of us has human rights. Now, what is human rights? You are born with a right. The moment you are born here in the world, you get certain rights. Now, what happened in 1948, I'm trying to get you the background of fundamental rights. Actually, fundamental rights are human rights. Now, in 1945, we had the World War II, and there was atrocities, Nazi, German, all that happened. And the United Nations at that time felt that we should have a Declaration of Human Rights. And that is United Nations Declaration of Human Rights, UDHR, that came into being in 1948. But it was only a declaration of human rights. So in that kind of a context, what was required was something that is rather a treaty where people could sign up. The state parties can sign and be responsible. So in 1966, there was 2 covenants. The first covenant was International Covenant on Civil and Political Rights. The second one was International Covenant on Economic, Social, and Cultural Rights. Now, those were adopted in 1966, but certain states are required to come into force. So in 1976, it came into force. Now, when it came into force, Sri Lanka signed the ICCPR, that is International Civil and Political Rights. So by that time, we had 1972 Constitution in Sri Lanka. They had fundamental rights, but there was no enforceable mechanism. You could not implement it. If there is any breach or infringement, there was no process in 1972 in the independent Sri Lanka. Now came 1978 Constitution. There, they brought in a concept called fundamental rights, which is there in India too. What is fundamental? Basics. That's what you mean. So they brought in basically all major important civil and political rights from Article 10 to 14 and brought in civil and political rights as fundamental rights. Now, the issue is those are the fundamental rights that is enshrined in the Constitution. That is there in the Constitution. And if the state breaches it, you have a right to go to the Supreme Court of Sri Lanka within 30 days and get your relief or remedy. So now it is enforceable. So let me explain, since I have to define basically what is it. It is about executive and administrative action. Executive, as Montesquieu pointed out, is executive, legislature, and judiciary. As you know, legislature make the law, executive implement the law, and judiciary interpret them. So when executive goes and try to implement the law, it violates fundamental rights. And we call it administrative law too. So our Article 126, my other colleagues, legal lawyer, my colleagues, my learned friends who are after me will explain the whole process with you and certain issues, but I am there to define. But definition is that it has to be executive and administrative action. Now, what is executive and administrative? We had series of cases. I mean, if it is a government department, fine, it is within. Or any minister, it is within. But a question arose like Insurance Corporation of Sri Lanka, Sri Lankan Airlines. Now, whether those are executive. So there was a huge debate in court, and there are 4 or 5 judgments which said that if there is a full control of the state, that falls under this. So now it is so widened, not only departments, not only ministers, but even Sri Lanka, which has a full control of state, like Sri Lankan Airlines, Insurance Corporation of Sri Lanka, Port Authority, their actions can be brought in under this. Now that is what it is. And then very interestingly, if you look at Article 126, it covers basically infringement and imminent infringement. Now, infringement is already done. Your fundamental rights are infringed. You can go. But very interesting thing is, if it is imminent, it is going to happen now in the future, then also you can come. Now, that is very important because that is to prevent. That is to prevent. Earlier one, when there is an infringement, you come there because it has already happened. But the futuristic one, preventable one, also can come in because Article 126 says imminent infringement. So that is a very wide scope. So any executive administrative action which violates, infringe your rights, you can come. Or even imminent infringement, you can come. Now let us finally go one by one. Now I like to take you through articles in the Constitution one by one, but I want to say those are there defining what the fundamental rights are. But interestingly, I like you to understand, when you talk of executive and administrative action, there is one very interesting article which you must refer, 12.8. Now that is military, that is Army, Navy, Air Force. The police will not apply Article 12, 13, 14. If it is to proper maintenance of discipline. So please remember, if you are in the military, if you are in the armed forces, there can be discriminatory laws, discriminatory action. They can be arrested. That is Article 13. Article 14 has so many, like freedom of expression. You can, I mean, you and I, citizens, have a freedom of expression. But armed forces, no. There is no freedom of trade union. No. Freedom of movement. No. So this very interesting Article 12.8, you need to understand. There is a segment of society in Sri Lanka, which is military and the police and the special forces like STF, where the fundamental rights will not apply. Now, that's important. So let me now take you through one by one. And most importantly, what I like to take you through in each these segments, Article 15. 15. What are those? Those are the limitations. Now, what does it mean? There are certain rights that is it to me that I should keep it in horizontal?
No, sir, you may continue.
Okay, thanks. Ladies and gentlemen, in that kind of a context, each article, some articles has no limitation. Some fundamental rights has a wide scope of limitation. Now, this is very important because no one should understand, get a feeling, I have the fundamental rights. I can do whatever I want. No, the government can limit it in certain areas. Government, there are certain things that government or the state, executive and the administration cannot limit. So let me take one by one. Article 10 is about thought, conscience, and religion. Now, I can think, I can have a good conscience. Now, that is there. That's a fundamental right that everyone has. Now, interestingly, I like you to say there is a distinction. Here, it is for every person who is within the geography of Sri Lanka. What does it mean? It is even for a foreigner. I like to repeat, not only citizens, every foreigner even should have the thought, conscience, and religion. So I said, can you limit it? No, you can't limit anyone's thought, anyone's conscience, anyone's practicing his religion, including foreigners. Now that is very, very critical, very important, because what's the point? We all as human beings have to think. We must have a conscience. We must practice our religion. Now that is given under Article 10 with no limitation and to everyone. Next is what? Torture, cruel and inhuman degrading treatment. Now, I like to take you through, this is a jus cogens. Jus cogens means it is an internationally accepted offense. It's a crime. Now, certain crimes can be in Sri Lanka, which are not crimes in Saudi, which crimes may not be in England. But torture is an accepted, internationally accepted offense. And when you have torture, and if it is cruel and inhuman degrading treatment, that is to everyone. No foreigner can be tortured. And I like you to repeat again, like the earlier one, no limitation. So let me explain. Torture is somewhat, we have a torture convention. We went and signed that in 1984. We have a law in Sri Lanka which makes executive torturing punishable offense. So when a police officer tortures you, it's a criminal offense which has a minimum 2 years. Minimum 2 years. So that's not only a fundamental rights breach, it's an offense now in Sri Lanka. I want you to appreciate and understand. And degrading treatment. Now, there was a case, husband and husband was a lawyer. They were driving a car, and the police officer slapped the lawyer husband. So, in front of the wife. Now, that can't be torture, no. Torture means you give all the kind of cruel and things. You torture, hate, and do so many things. But just a slap is not a torture. I mean, you feel it. But it was inhuman and degrading treatment. So it's so wide. Even in a village, a village woman, again, slapped by a police officer, they said, it is very inhuman and especially degrading. Now that torture and inhuman and degrading treatment cannot be limited. It's a fully powered one, and it applies to everyone. Next comes Article 12. What does it say? It says that everyone is equal before the law, and that is rule of law. You have learned as law students, and everyone should know that we have a rule of law. So everyone is equal before the law, and they get equal protection of law. Now, this is to all persons. What does it mean? The court has gone through a lot of judgments, and they say when an executive and administrator takes an arbitrary decision, arbitrary, with no basis, no reasonables, now that means they are not getting that equal protection of law. So if I make a distinction with arbitrary, I want to do this way, that is not equal protection of law. That is not equal before law. So then that is to all persons. And that has also, we'll get to limitations later. Then 12.2 is a very interesting one. No one can be discriminated based on several grounds. Let me read one. Race, religion, language, caste, sex, political opinion, place of birth, or any one of such ground. You cannot discriminate anyone on these grounds. So this is a discriminatory one. So state can't discriminate on these lines. But I want to stress here, this discrimination part of 12.2 is only for citizens. Puravasiya. Citizens. I want you to get that distinction. Earlier one for everyone. But discrimination part is only for citizens. Foreigner can't say, I was discriminated because I am man, woman, or race, or whatever. That does not apply to a non-citizen. So this is a very interesting scenario. But what are the limitations? You must go through Article 15.7. It covers every area. I'll go through fast. National security, public order, protection of public health and morality, for the purpose of due recognition of right and person of others. And very interestingly, just requirement of general welfare of democratic society. So you can see a wide area. You can discriminate because of national security. You can I'm just giving an example. You can discriminate on public order. And if it is for public health and morality, we saw in COVID certain discriminatory grounds. You can't now challenge because it's public health. Morality is so wide. What is morally right and wrong is a very huge area. So this is a huge area of limitations for Article 12, which I read through. So I want you to appreciate that. Then comes Article 13. It's all about criminal offense. Now that is what do you mean? 13.1 is for everyone, not only citizen, to everyone. What does it mean? 13.1 says you can't arrest except according to procedure. Now you must, now here it is where criminal procedure get connected. We have something called Criminal Procedure Code, which came into being in 1979. So that is connected here. How does it connect? Because there is a procedure laid. You must hold it, and then you must tell him the charges. So those are the ways of arrest. And then after arrest, you detain, you keep him in a particular place. Now, that can't be done. That is under 13.2. Custody, detain. You must take it to the judge of the closest competent court. Now, these are also subject to limitation in 15.7, like what I said before. Then 13.3, person charged should be entitled to an attorney at law. 13.4, this is very interesting. No one should be punished with death or imprisonment except by a proceedings. Now, we know murder, heroin, all those get death punishment. So you must go through the procedure, the laid down procedure. And I want to tell you, you can't, just for your information, you can't plead guilty for murder. Now, I have committed my murder of my son or my wife. I regret a lot, and I want to plead guilty. You can't. You can't. Because it's like suicide. A trial must go. Trial must happen. Even if I regret and plead guilty, trial will go with evidence. And if there is no evidence, I get acquitted. Why? Because it's a fundamental right. It's an accepted norm. And even there must be 2 appeals. Even if I get convicted, after that, I say I don't want to appeal. You can't. The jailer will send an appeal on your behalf. Because that's a scrutiny, because this is where judiciary makes a man to be killed and the executive arm killed. You can't have a government killing a person without a good procedure. So that is under 13.4, and that has no limitation. 13.5, you all know in criminal law, until proven innocent, until innocent is proven guilty, you are proven innocent. Now that is 13.5. And 13.6 is a very interesting one, which can be limited under national security 15.1. And that is retrospective legislation. What does it mean? Now you can't pass a law now and say, it applies to the earlier incidents. It only applies to the future actions. Obviously, otherwise, how do I know a law will come in the future? No one should know. I should know a law that is applicable now so that I can get convicted. Now that is 30. The last point I like to talk about is Article 40. Now I want to stress here, this is only for citizens. Citizens. Now, first one is freedom of expression and speech. It is huge. They said public protest. Now you see public protest using placards. That is 14.1a. Very important. Freedom of expression. And even very interestingly, whether in the case of Karunathala, one case, they said freedom of voting is a fundamental right. They even went on to say, rather than even, normally you think making a speech in the political platform is a freedom. Yes. But they said freedom to vote is more important, is more valuable than even public speech. So that is brought in. So it has a wide spectrum. One who used a musical instrument and that was destroyed. That was found to be wrong. Because people can express. The whole Aragalaya and what is happening, yes, all come under this. But then you will ask me, what are the limitations? Go through 15.2, which says, in the interest of racial and religious harmony, you can receive. Now that means I am a Buddhist. Can I go and start criticizing other religions? Can I call Dalai Maliga a labba? I'm using an exact scenario. What happened? You can't, because it hurts people's feelings. My freedom of expression is limited to that. And it is limited with parliamentary privilege. It's limited with contempt of court. It's limited with defamation. Now that is Article 14.1a. And then we have freedom of peaceful assembly. We have freedom of association. You can form your alumni association of your school. We have a right to form our association. And I have a anyone has a freedom to join trade union, no limitations. You have a right to manifest your religion. I can do Bodhi Pujas, Kovil Pujas, I can pray anytime. There also can't be limitations. And I must enjoy my culture, and that is F. So you must go through 14. There are different areas that is limited to citizens. And except 14.1a, freedom of expression, that has certain limitations that I explained to you. Rest, like trade unions and culture and manifesting religions, no one can live in. So ladies and gentlemen, you can see this is a huge scope. It's a very important one, because this is what we are born with. And in Sri Lanka, under fundamental rights, we have a right to go to Supreme Court and get a declaration if all this, what I have defined you as fundamental rights is violated. So thank you. And when Munivara called me and said, please come in, I was so overwhelmed. IDM University, thanks for giving me this opportunity, sharing this. Unfortunately, I have to go halfway to another personal commitment. So I may leave out halfway. I will try to be as long as possible in this. Thank you, Gimhan. Over to you.
Right. Thank you very much, sir. I am well aware that your schedule is like really busy, professional commitments as well as personal commitments. But you did allocate time for us, and that was such a wonderful session. So my memory certainly ran back to a couple of years. I felt like I was a law student again, sitting in a classroom listening to one of your lectures. So it's always very exciting and satisfying to sit through your explanations. So thank you very much. And the participants, attendees, you all should feel, I guess, privileged, because I'm telling you with experience, to be taught by him is actually a privilege. Like, he's one of the most senior and one of the most reputed lecturers in the country. So thank you very much, sir. Thank you for making time for us. We actually have a couple of questions, but we can have those questions for the other panelists today. So thank you very much, sir. Once again, thank you on behalf of IDM National Campus for allocating your time for us, sir. Thank you very much. Right. So with that, we are moving on to our next panelist, Mr. Bhadraka Manamendra. Right. So Mr. Bhadraka Manamendra is also an attorney at law, and I used to know him from university days itself. He's one of the most active young attorneys in the country at the moment. So welcome to the show, and I would like to direct you the next question that we have, which is the current status of fundamental rights in Sri Lanka. So Prasantha Lal also covered that briefly, but he mostly explained the definition of fundamental rights and the applications. So Bhadraka, I would like to ask you the current status of the fundamental rights of Sri Lanka, and also Prasantha Lal also initially mentioned how it was the idea of fundamental rights first came from Salisbury Constitution with Article 29.2, but then like something that was specifically named fundamental rights was introduced in 1972, but it had the issue of not being effective enough. And currently under the 78 Constitution, we have legally protected fundamental rights, which means that we have certain remedies available. Now, today, Mr. Nirmal Poornajith will be specifically speaking about the remedies. So I would like to ask you, how would you define the status of fundamental rights in Sri Lanka, especially comparing to other countries? Also, we have a few questions in the chat box. Once your explanation is done, we can move on to the questions as well.
Good evening, Gimhan. First of all, I like to thank Mr. Gimhan Sooriyabandara for inviting me this webinar. And actually, regarding the nature and scope about the fundamental rights, most of the areas has been covered by the Prasantha Lal sir. And before I am coming into the current status of the fundamental rights of Sri Lanka, I like to talk about a little regarding the history of fundamental rights in Sri Lanka, because it is necessary to have a foundation before we coming into the current status of the fundamental rights of Sri Lanka. Now, I want to move your attention to the Independence Constitution of Ceylon, which I believe that is where we started about talking about the fundamental rights. It is like this: the Independence Constitution of Ceylon did not actually embody a Bill of Fundamental Rights, but the nearest it came to one was through Section 29 of that Constitution. When we talk about the Section 29(2), provided that no law passed by Parliament shall, for instance, prohibit or restrict the free exercise of any religion or make persons of any community or religion liable to disabilities or restrictions to which persons of other communities or religions are not made liable. This section, which had been designed to protect the interest of minority communities, actually failed to protect individuals against the discrimination. But that is the first step, I believe, in our constitutional law history, that we started to protect rights of the people. After that, actually, we can see when we get look into the Lianage versus Queen case. That is a landmark case which we can talk about the fundamental rights in Sri Lanka. I believe we have most of the law students joined today. So I believe Lianage versus Queen is the starting point which you have to read and take idea how Sri Lankan law have changed regarding the fundamental rights. And then the first Republican Constitution, that is 1972, inherited a new number of fundamental rights in Section 18(1), all of which were to be operative within certain confines or limitations stated in Section 18(2), which apply to all those rights equally. But we know when we come to 1972 Constitution, if there are any breach regarding these fundamental rights, there was no way to enforce these rights. So what is the best thing happened in 1978 Constitution? The Bill of Rights in the present Constitution of Sri Lanka is quite elaborate. The several rights enumerated there are not all subject to blanket restrictions. So I believe 1978 Constitution actually Prasantha Lal sir was actually covered all the almost all the rights of this 1978 Constitution. But I'd like to talk about when we're talking about the current status regarding the 1978 Constitution. I'm moving all attention to the 19th Amendment. That is where we got a chance about the right of access to the information. That is inserted by the Section 2 of the 19th Amendment to the Constitution. Actually, in that is the current development of the 1978 Constitution in a very that is in 2015, you know. And that I like to talk about the Section 14A(3). That is where in this article, citizen includes a body whether incorporated or unincorporated, if not less than 3/4 of the members of such body are citizens. So that is a new development which includes to the Constitution. That is, a citizen is not only a person. That could be a incorporated or unincorporated body also. So I believe that is a new development of law. And when we talking about when we comparing our rights with the other jurisdictions, actually I believe, my personal view, that now in Sri Lanka, we as citizens or a person, if there is a breach of right, we have to go to Supreme Court. Now that is, we know only Supreme Court is in Colombo, and that is not accessible to every and each citizen or person in Sri Lanka, because when we go to the rural villages, there are so many issues that they have. Actually, we know law is little cost. They allow, so they don't have money to come to Colombo and access their rights and what come to the courts. So it is better to have a mechanism to at least take this jurisdiction to the provincial high courts and give a jurisdiction to provincial high court judges also to have jurisdiction to persons to come to courts and have a case regarding their breach of fundamental rights. It will be a very good development in future, and I believe that is the best way. Because even other jurisdictions also in other countries also there are so many other ways to as these things. Gimhan, can you hear me?
Yes, you may proceed. Loud and clear.
Yes. So I believe that those are the actually most of the areas have been covered from the Mr. Prasantha Lal, sir. So I believe that is my point of view regarding the current development.
Right. Okay. We actually have a few questions. Someone has asked about Queen versus Lienage, like a brief explanation.
Yes. Now the Queen versus Lienage case is of that is 1965, 68 NLR, page number 265. Now this case was the position taken by the courts that judicial power under the Independence Constitution was exclusively vested in the judiciary, leading judiciary, which held that the legislator could not use up or infringe judicial power. In fact, resulted in upholding the equality before the law, although there was no constitutional provision to the effect. That's what they held. The Lienage versus Queen, actually, that is what they held, and that is not actually regarding. That is what that is about the judicial review. Because we know in our Independence Constitution doesn't have a fundamental rights chapter, but that this Lienage versus Queen case is about the section 29(2), which stated which held about the judicial review, how this should be reviewed.
Right. Also, we also have a question of this is one of the most commonly asked questions about fundamental rights in Sri Lanka. What about right to life? Is it not included in the?
Yes. Actually, in 1972 Constitution, we had that. We know 1972 Constitution, but if there is a breach, we know we can't. There was no mechanism to enforcement. But when it's come to 1978 Constitution, I don't know what is the reason. The right to life is not there. But in 1972 Constitution, that was there. But when it's come to 1978 Constitution, for a reason, I don't know what is the reason, that was not there. But we know 1972 Constitution, there is no way to enforce the right. But when it's come to 1978 Constitution, there is a way to enforce, but right to life is not there. But I believe when we develop our society, the right to life is a very important right to have, because that is the main thing which, because if we can't live in peacefully, there is no other thing which we can alter it. So we can have all the other things, but without having the right to life is, I don't believe that the other rights are, that's it.
Right. Okay. So maybe one last question for you before moving on to the next speaker. Another question is asked regarding private institutions which has government influence and control, such as Sri Lankan Airlines. Does fundamental rights chapter have any application in such cases?
I didn't get you, Gimhan, sorry.
Actually, the question, it's the way it is sort of like typed, it's a little difficult for me also to understand exactly what they mean. But I'm trying to figure out, I think the question is that when it comes to matters where private institutions being influenced or controlled by the government, for example, Sri Lankan Airlines, does the fundamental rights chapter have any applicability in such cases? I think they're asking about privatization of government, privatization of government institutions.
But actually, it is like this, Gimhan. we know there is another chapter regarding the there is a directive principle of state policy and fundamental duties, that is chapter 6. But we know that is Article 29 states the provisions of this chapter do not confer or impose legal rights or obligations and are not enforceable in any court or tribunal. So that is so we can't go to courts and say that the government policy is this, they are privatizing this and that, so you should stop it. But that is comes under that directives to the state policy and fundamental duties. But if someone thinks that if there is a breach of a fundamental right of his person or citizen, that after privatization from privatizing the Sri Lankan Airlines, they can go to courts and ask for a. He can go and tell it to the, but I don't believe that will be, because this fundamental rights are regarding something else. Because that is comes under chapter 6 actually, but we don't have a provision right now to enforce it.
Right. All right, thank you very much. That was actually quite helpful. The questions were answered. By the way, that we are receiving a lot of questions. We won't be able to entertain all. We are trying to address as many as we can. So thank you, Bhadraka, for allocating your time on such short notice to come and help us. I certainly hope the attendees found it interesting.
I also like to thank Mr. Gimhan for inviting me this webinar.
Right. Okay. Thank you very much, Bhadraka. So our next panelist is Mr. Nirmal Poornajith, who also happens to be another young attorney who is same age as I am, just like Mr. Bhadraka Manamendra. All of us, we did A-levels in the same year, and we attended University of Colombo in the same years. So he too is an active young attorney, and he's also quite enthusiastic in educating the new generation, younger generation. So he too accepted my invitation on short notice. He also agreed to allocate time for us. First of all, thank you. Welcome to the discussion. So first we'll ask the basic question from you. So Nirmal, the question that is directed to you, which is the main topic for today, is that what are the remedies available for fundamental right infringements or violations in such case? So I think we initially discussed about Supreme Court as the mainstream remedy. I think Mr. Prasantha Lal De Alwis and Mr. Bhadraka Manamendra both spoke about this aspect. Other than that, we have other options such as filing a complaint to the Ombudsman, or maybe filing a complaint to the Human Rights Commission. So what else are the other options we have? And of course, if there is anything which wasn't covered by the previous two speakers regarding the Supreme Court procedure. So basically, we would like to direct the question to you regarding the practical aspect of seeking a remedy in cases of fundamental rights violations. After your explanation on that is done, we will give you a few questions given by our attendees today. Right, over to you, Nirmal.
Okay, thank you, Gimhan, for inviting me. And I should thank Senior Counsel Mr. Prasantha Lal De Alwis and my friend Bhadraka Manamendra for paving the way up to here with their richful knowledge. So the question you directed me, Gimhan, now we all know that by our constitution, we have been given the privilege to go to the Supreme Court seeking relief if our fundamental rights are infringed, right? So this is the court procedure. So I'm going to focus on the alternatives, on the alternative ways available for someone if their rights are infringed, right? So first I'll speak of the Human Rights Commission, right? We use this widely, we use this phrase widely, and we on televisions, media channels, we see everyday people going to the Human Rights Commission and lodging complaints, but we have to see what's actually happening inside this particular institution, right? So, first thing, now other than going to court, right? What prevents people from going to Human Rights Commission, right? The first thing I see is the ignorance of the people, that they do not know there's something called the Human Rights Committee. Like people from the urban areas, they might know, but if you go to a remote area and if you ask a question, do you know what's Human Rights Commission? Certainly the answer would be no, right? So the second thing is the socio-economic factors. So this is not a fault of the legal system, but maybe because people do not have enough, financial capacity, they might hesitate to come to a city and go and lodge a complaint to the Human Rights Commission. Then the other thing is the general public, they usually think that the process of lodging a human rights complaint to the Human Rights Commission is complex, as much as a court procedure. So I have to tell you that people should know this process is not complex as a court procedure, right? And the other thing is, people are of the view, generally people are of the view that they need a lawyer, they need to retain a lawyer to go to the Human Rights Commission with them. So the actual situation is, this process is very simple, and you do not need a lawyer to go with you to the Human Rights Commission. You can just go there, you can just write down your grievance and submit it to the Human Rights Commission. So now you know that this process is not complex, and essentially it's not essential for a lawyer to be there with you. Right? What's the process? So now you know simply that you can go and present your grievance in writing to the Human Rights Commission. So what does it do then? Does this have a judicial power? Are the decisions binding? That's what we have to discuss next. Okay? So first you have to understand the fact that Human Rights Commission is not a decision body. The decisions, the recommendations, the decisions taken by the Human Rights Commission, it does not have a binding power. That's a deficiency, that's a shortcoming, but I will come to that later. So what Human Rights Commission does, it calls for an investigation. Once a complaint is lodged there, once a complaint is filed there, it calls for an investigation, right? Informing the relevant parties, it summons and conducts an investigation, and they come to a conclusion and they give a recommendation. So then one can ask, so as to why then, if this does not have a binding power, the decision given by the Human Rights Commission investigation, if it does not have a binding power, why should I go to the Human Rights Commission? Someone can ask like this. So you have to have this in your mind. There's often we see in courts. Now you know that. Let me explain it like this. Now you know, if one of your fundamental rights are infringed or is about to be infringed, you should go to the court within 30 days, right? But if you go to the when your fundamental right is infringed, and if you go to the Human Rights Commission at once and files the complaint, until that case is investigated and decided, that clock ticking of 30 days does not start, right? So means if you go complain to the Human Rights Commission, And when the investigation is over, only when the investigation is over, the period of 30 days starts, right? So that gives you ample time to get ready for a lawsuit if you expect to go to the court. So that's one thing that you should keep in your mind. The other thing is, when you go to the Human Rights Commission, right, it creates a dialogue. Right? Maybe we've seen people fetching media and going to the human rights and giving statements. Right? This creates some sort of dialogue within the society, right? That attracts attention. So even though it's not a judicial process, something essential for a firm lawsuit, that gives some sort of social push or swing for someone to carry forward their case. Right? This is not judicial or legal, but we have to keep in our mind that it creates some sort of time. So that's important, especially in a country like Sri Lanka, that could come handy somewhere down the line. The other thing is, people don't, like the general public, they usually they do not know that mediation and reconciliation is one of the ways the Human Rights Commission tries to find solutions for the complaints lodged. Right? For an example, Gimhan, now within the past year, if you go to the Human Rights Commission data and if you go through their annual reports, you could see around 6,000 complaints have been lodged to the lodged in the Human Rights Commission, right? So around 1,000 of them has been directed to has been ended with mediation and reconciliation. So it's a valuable job carried out by the Human Rights Commission. The other thing is, especially in areas out of Colombo, we can see people do not know to which proper forum they should take their grievance or the problem to, right? So another job done by the Human Rights Commission is to direct people to the correct forum that they should go to. So these are the basic tasks of the Human Rights Commission. And I would like to give you some insights about, because people usually they do not know what the real value of the Human Rights Commission is. It's because of the reason, here in Sri Lanka, parties affiliated to different political ideologies, they use this Human Rights Commission for propaganda. Right? We all know that. We have to accept the reality on the ground. They take a, they come up with the case, they call the media, they just go make a very big media boom, and it's all gone, all silent, no result comes, right? So people really do not know, other than this, the general public, they do not know the what's really done by the Human Rights Commission. So, for an example, some recommendations, some investigations and inquiries, right? I'll briefly go through them. So you all should have heard of the Mahara prison incident, where some detainees started sort of riot during the COVID period, right? And they were shot. And when it was inquired into, it was said that to control the situation, shots were fired, right? So at this incident, the Human Rights Commission immediately went there, conducted an investigation, and issued interim recommendations, right, to the IGP to handle the situation without harming any further remandees or the prisoners. Then the outreach, there are a number of outreach programs conducted by the Human Rights Commission. Basically, they are awareness programs, right? They come, they teach you what human rights are, because you should know what your human rights are to know if they are infringed or not. Then there's another very important thing, the recommendations given to the government of Sri Lanka. So you have seen use of sign language on television channels, right? This is a very important request made by the Human Rights Commission of Sri Lanka to all television channels, but I don't know whether this is being implemented or not. And then the escalation of deaths of persons in police custody, right? You all know, you all hear about these incidents abundantly, where we say, right? So this has been this has caught the concern of the Human Rights Commission of Sri Lanka. So we on their own volition, right? They directed the IGP to submit a comprehensive report on what's happening, right? So Human Rights Commission has intervened in the question of Fatima Sadia. She's she's said to be the wife of the be the wife of Saharan Hasib. You all know the incident, but so you know, they requested to ensure the security of that particular lady. She was a remandee then, because you know, here in Sri Lanka, evidence of the important evidence of some cases, court cases, might get erased, you know, depending on some circumstances or needs of the politicians. So there is a need of protecting witnesses or the remandees in some cases. So these are the basics about Human Rights Commission. I hope you got some knowledge, and I'll speak of the post of ombudsman in Sri Lanka. This is a rarely sought after relief, but the basics you should know. In a situation, in an instance where your rights are infringed, fundamental rights are infringed, you can complain it to the ombudsman, right? People usually do not do this, but you have this option. That process is also very simple. By registered post or normal post, you can direct your grievance to the ombudsman, right? Or else you can write it in an email message, or else you can hand deliver your grievance to the ombudsman, right? So then what's needed is the complaint shall be clearly written on a paper, and you should write against whom you are pleading the relief, and what relief exactly you expect from the ombudsman, right? So in the same way as a Human Rights Commission works, it will call reports from the particular parties and try to conduct an investigation without summoning the parties, and come to a conclusion, make recommendations regarding the relief sought after. So that's it, Gimhan.
Right.
I will.
Thank you. That was actually a very, interesting and very useful content and knowledge that you shared with us. That was actually quite important, because especially we had a question we received in the question and answers panel that what are the things that you can do to delay, like prevent court delays. And when you talked about the whole Human Rights Commission and their involvement, I think that actually answered a lot of those questions as well. So I would just I would direct you one more question that we have from the attendees, and then we can move on to Mr. Asel De Silva. For students, the most important part we will be discussing with Mr. Asel De Silva regarding the importance of learning fundamental rights for a law student, right? So before that, just one question I've received. Actually, we have two questions. Firstly, there's a question: how does the government balance the national security concerns with the protection of fundamental rights? How do you balance out the two?
Very tricky question, Gimhan, because the thing is, so how can I answer? Let me say something like this, right? What the Constitution says, even I don't have the English version of the Constitution here with me. 15(6) Constitution. What it says, 14 වන ව්‍යවස්ථාවේ පළවෙනි අනුව්‍යවස්ථාවේ උච්ඡේදය ප්‍රකාශ කොට පිළිගෙන ඇති මූලික අයිතිවාසිකම් උක්ති විදිය හැක්කේද ක්‍රියාත්මක කළ හැක්කේද ආර්ථික ආරක්ෂා කිරීම සඳහා නීති නියම කරනු ලැබිය හැකි සීමා කිරීම වලට යටත් වෙන. Right? What it says, fundamental rights can be entertained, but what comes first is the national security. Right? This is what the Constitution says. But there are very delicate incidents in her, right? Under the cover of the, this kind of sections, constitutions, the government may try to infringe the rights of the peoples. We know him, and we have to accept the fact that people have gone missing within the unfortunate 30 years war which prevailed in Sri Lanka. So that's why I said, Gimhan, it's not only the so according to the Constitution, what comes first is the national security, but there should always be this social dialogue, this fight against the suppressions of the government. If they are using the Constitution to suppress people, to do unlawful things, so there should be something, from the side of the aspect of the people. That's what we saw during the recent conditions which developed in Sri Lanka. So
Right.
That's the answer, Gimhan, I can give.
Right. Okay. Thank you. We actually received a few questions regarding the Anti-Terrorism Act and the limitations of fundamental rights as well. But like, I don't think, first of all, it's a longer discussion. We don't have necessarily the time for that. Plus, it's a little controversial and political, and today's session we are focusing on the academic side of it. So we will discuss about it on some other day. One small question that I have before moving on to Mr. Asel De Silva is that there's a question: does the 30-day time bar stop a complaint being made to the ombudsman as well?
Gimhan, the question is not clear to me.
The question is, does the 30-day time bar stop
No.
to the ombudsman?
No, it does not apply, Gimhan. Very good question. It just says within a reasonable period of time.
Right. So
that depends.
The time bar is only for Supreme Court.
That is
right. All right. Okay. So thank you, Nirmal, for joining our session and for that wonderful insight.
Gimhan, I want to thank you as well. You are doing a great job. Thank you very much.
Okay. Thank you. Right. So we are moving to our last panelist. And of course, since given that most of our attendees today are law students, and this session being hosted by IDM Nations campus, which is connected to the Bucks University. So this is a law school pretty much. And secondly, even the Rotary Club of Pan Colombo, who is helping us today, partnering with us, their members are also students. Some of them are interested in studying law. Also, my debating society, CIDS, which have been like, helping out the coordination and all that. Even our students, some of them are law students already. Some of them are prospective law students planning to study law in the future. So we're actually moving on to the most important part from a personal perspective for most of these attendees. How important learning fundamental rights is for a law student. And I think Asel is ideally the best person to discuss about this, because he's been a mooting coach and he has been into the education side of the legal education side quite a lot. Comparing to the other speakers, someone I got to know recently, but I've got to know him reasonably well for the short time period that we've spent together. So he was nice enough to accept my invitation again on such short notice to take part in this event. So thank you for coming, Asel, and welcome to the discussion. So basically the question to you is that how important it is to learn fundamental rights for a law student, how important it is, how useful it is going to be for your career as a law student. And other than that, we have a few questions in the box. I will send them to you once you're done with your explanation.
Thank you so much, Gimhan, for that very nice introduction. And yeah, so good evening to everyone who is present today. I think Prasantha sir and other two distinguished lawyers explained about fundamental rights more precisely, which all of you would agree that you understood through their demonstration, right? So, Gimhan, before answering to the question as to the how important it is to learn fundamental rights as a law student, I'll just say the significance of the fundamental rights. So I'll explain about firstly on that and get back to so as citizens of Sri Lanka, it is important that we understand our rights and how they can be protected. So we are law students and we should know, so we are as budding lawyers, we should know that there's a significance of the fundamental rights, and in order to appear on behalf of the citizens of Sri Lanka to protect, to make sure that their rights have been protected. So we should learn fundamental rights. As you heard earlier from our panelists, fundamental rights are basic human rights that are guaranteed by law, basically the Constitution. These rights are essential, ensuring that the individuals are treated fairly and are able to live in dignity, right? So in Sri Lanka, the Constitution guarantees fundamental rights to all citizens, and Constitution also provides for the establishment of a Human Rights Commission, whose primary role is to investigate violation, as the previous panelist said, violation of human rights, and to promote and protect human rights in Sri Lanka. This is where I learned most about fundamental rights, since I have worked there for quite a bit long. So in Sri Lanka, most of the cases that are currently determining in the Supreme Court are fundamental rights applications. Basically, which it means is that there are so many instances where people's fundamental rights are violated around the country. So it is no doubt clear that the people should be aware of the fundamental rights that they are guaranteed by the Constitution. Also, as budding lawyers, we should understand the importance of fundamental rights in order to act upon it and learn it very briefly. So fundamental rights, according to my knowledge, fundamental rights are not only ensure and guarantee the basic civil, political, social, economic rights, but they are also fulfill the important functions of safeguarding the minority communities, castes, classes, religious groups, and removing the notion of discrimination of all kinds, and ensuring equality. So these rights are a part of the basic structure of Constitution, and so they cannot be abridged or infringed, right, by any constitutional laws, provisions, or amendments. So if this happens, then that particular law will be declared as unconstitutional and void for being against the norms of the Constitution. So fundamental rights are also the individual rights or the basic rights without which the modern constitutional democracy is meaningless. And so they entrench with the understanding that these cannot be infringed or taken away by any ordinary law or provision. Not only for the advancement of the people and expansion of the societies, but these basic rights are also needed for protecting the people from violations or excesses of state, as a state is considered to be the biggest violator of human rights. So fundamental rights, as explained by our previous panelists, fundamental rights are always planned to protect and ensure not only the dignity, as I said previously, of individuals, but also it creates some situations that can help every human being to develop their character to its comprehensive extent. despite they enforces an undesirable duty on the state, that is of not encroaching on individual liberty in its various dimensions, it forms the base or a root for the very concept of human rights, and they are most indispensable for any accomplishment by the individual for his exhaustive intellectual, moral, or spiritual status, right? So the main aim for inclusion of the fundamental rights and the need to learn about fundamental rights as law students in the Constitution was to institute a government of laws and not of man, where under the rule of man, the society would be unsystematic and unrestrained. But with the rule of law, the peace and harmony will be maintained in society, hence ensuring justice and equality. So according to that, the fundamental rights are not only safeguards of freedom, but also guarantee the right to live a dignified life and a personal liberty of citizens against any incursion by the state. And henceforth, these liberties will play a crucial role in preventing or foiling the establishment of authorization or authoritarian and undemocratic rule in the country. And so it's very essential for assuring an all-round burgeoning of individuals of the country. Therefore, these are basic human rights which are very crucial, not only not for the human existence, but also human development. Fundamental rights are widespread, which means they are pragmatic to all citizens of Sri Lanka equally. That is, irrespective of their race, birthplace, religion, caste, sex, or culture, position, occupation, or identity, as explained by our Albion of Prasantha. So the importance of learning human rights, fundamental rights, as law students is for the fact that when it comes to when we become lawyers, so there are so many people around the country who needs to stand for them, appear before the Supreme Court, appear before the Human Rights Commission. So in order for that, we need to learn about human rights. As budding lawyers, we need to learn about human rights in order to safeguard people's right and to uplift the rule of law and good governance in the country. And also, there are so many scholarships available for the law students to learn about human rights in other countries, such as Strasbourg, where they have, the Human Rights Court. You can, I'll try to find the particular scholarship for you to anyone can apply. If you get it, you can learn about fundamental rights, which will help you in your future as lawyers to help and to make justice for the public good. Thank you so much, Gimhan. I hope that answers the question that you posed to me.
Yes, Asel, thank you very much. We actually have a few questions from the attendees. Could you explain how the international community can support the protection of fundamental rights in Sri Lanka?
Pardon, I didn't catch the question. See?
Could you explain how the international community can support the protection of fundamental rights in Sri Lanka? I think this person is asking about the role international community plays in protecting fundamental rights inside a country.
Yes, so according to my knowledge, so basically we have already in our constitution, our rights has been guaranteed by the constitution. So in order for the international people to support our fundamental, I think our independence of the judiciary is quite in a good standard. So in somehow internationally, how they can support Sri Lanka is to, it's still, I think it's still happening. There are international, either UN or other organizations around the world is not convincing per se, but supporting the Human Rights Commission to safeguard the rights guaranteed to the people in Sri Lanka. That's where I think they can't directly get involved in the process of getting the fundamental rights, the process of getting the fundamental rights protected in the Supreme Court or any other tribunal. So it's basically what they can do is they can internationally support by writing to the Human Rights Commission and writing to the top level state agencies in Sri Lanka.
Okay, sorry about the delay. I had a power cut. I just had a power interruption. I just got it. Okay. One more question for you. Are fundamental rights law good in Sri Lanka compared to other countries in South Asia?
Well, I don't think it's right to share my personal opinion on this, but I think Sri Lanka, we have a good constitution, and that's the reason why there's no complaint over the protection of fundamental rights, other than like very handful of instances. So compared to other countries, I think Sri Lanka is a good stage at the moment, protecting. Protection. Otherwise, if I say my personal opinion, then I'll be get caught of court.
No, something to add to that as well. Sri Lanka and India are known as the two former British colonies who happen to have consistent democracy. In Sri Lanka and India, since independence, every government which came to power and every government which went out of power have always come through democracy, whereas other South Asian countries and Asian countries in general are struggling to keep democracy, let alone fundamental rights. So I guess Sri Lanka and India, comparing to other Asian and South Asian countries, Sri Lanka and India are in a progressive place. I think it's safe to say.
Yeah, I think yeah. So basically, we are using Indian authorities as well in courts as accordingly. So basically, that's the reason why that has been authoritative for our Supreme Court to as authorized. Right.
Right.
So,
right. Okay. So I think we can conclude your session as well, Asel. Thank you very much for allocating your time inside your busy schedule and spending time for us. We certainly hope that our attendees learned the most important part as law students, how important learning fundamental rights is. So thank you very much, Asel. Thank you for.
Thank you so much. Thank you so much, Gimhan, also for inviting me. And I'm honored to be in a panel where this President's Counsel, Prasantha is also in, and other two distinguished lawyers as well. Thank you so much.
All right. I have actually two more questions in the questions box, which I will answer myself, I guess. So, sir, briefly explain the difference between Article 10 and 14(1)(e). So basically, I think that the question is referring to Article 10, which discusses about your right to conscience, your right to belief, and 14(1)(e), which expresses your right to practice the religion and the culture that you want. So these two provisions sound very similar, but they are basically talking about two aspects. According to the question, I can explain that Article 10 is more like it's more like the theoretical side or like the principle side. Principally, you are allowed for your personal belief. You have your fundamental right to have your personal belief, right? And then Article 14(1)(e) ensures your right to practically practice it. For example, say that if I am following a certain religion, I have my right to believe in that religion. Now, believing is something that we have conceptually. It is not something practical. It's not something we can see in real life, right? It's something we believe. It's conceptual. So Article 10 assures the principal right that I have to believe what I want to believe. Now, that is not something that you can directly violate. Someone can't come and say, don't believe in this. Force me not to believe something. So Article 10 discusses about the principal side of it. Article 14(1)(e) discuss the practical side of it. So ideally, if someone is not letting you practice your religion or follow your religion or take part in cultural activities, whatever, then that's a violation of Article 14(1)(e), right? So it's basically like the principal side and the practical side of the same right. One more question, last question for tonight. How well can we make the general public aware of fundamental rights? I think that's what we are doing right now, hosting webinars, raising awareness. Like, sometimes even law students are there. maybe not being familiar with fundamental rights, that you have heard of fundamental rights. Now, for example, a lot of people do not know the difference between human rights and fundamental rights. Human rights are coming from the United Nations Charter of Human Rights, from UN, that they are given to everyone in the world. Wherever you are born as a human, you get the same set of human rights. The human rights I have right now is the same as someone who lives in USA, someone who lives in Russia, someone who lives in Saudi Arabia, someone who lives in Ethiopia, someone who lives in Mongolia. We all have the same set of human rights, because United Nations Charter of Human Rights says that you get the same set of human rights wherever you are born as a human. But fundamental rights are given to you under your constitution, and that is legally protected. Now, human rights are there, but when your human rights are violated, you can't take legal actions because it is given by UN, and UN is not your state. But the constitution is something that your state follows. So your constitution assures you fundamental rights. So a lot of people say, you are violating my human rights, I'm going to courts. That is, legally inaccurate. But you can go to courts when your fundamental rights are violated, right? So these are basic principle differences. I think most of this was covered today and explained to you very well. I believe that you are more aware, more knowledgeable than you entered this session today at 8:30 p.m. 1.5 hours later. I believe that you are more informed, more aware of fundamental rights than you were, right? So that's what we are doing. We are hosting these kind of events, webinars. IDM Nations Campus would be hosting an online webinar every month, and we will be hosting other sessions as well, right? We are hoping to partner up with other institutions like Rotary Club or my Debating Society CIDs. We are willing to help out IDM Nations Campus for their efforts. This is very should be appreciated, the efforts they are putting to raise the awareness. So IDM Nations Campus is doing a fantastic job for Bucks University, and I have to thank them for allowing me to coordinate this session, and I have to thank the Rotary Club of Pan Colombo and my team in CIDS for helping me to coordinate this event for IDM Nations Campus and also Bucks University. So we have done our part. We have taught you what fundamental rights are. Now it's your turn to go to your loved ones, your family, your friends. Yeah, when you meet up, when you're having when you meet your cousins and your uncles, aunts at all these parties and all of that, when they're talking about these topics, tell them what you learned, share what you learned. And that's the effort that we are trying to make here to raise the awareness. As the last question that was asked, we are trying to raise the awareness of citizens. So thank you again, IDM Nations Campus and Bucks University, for organizing this event. And I am honored as the president of CIDS, with collaboration with Rotary Club of Pan Colombo, to host and coordinate this session and moderate this session. Thank you for all the resource persons. Over to you, Ms. Anushika.
Right. Thank you, Gimhan. Thank you, everyone, being gathered on the quick notice that we have passed. So I must thank first and foremost all the panelists who joined, who took part in this session. So thanking from President Council's Prashanth, although he's not here. So I must give a warm appreciation on behalf of IDM Nations Campus. Thank you, Gimhan, to making all these knowledge people connected with IDM Nations Campus. So also Mr. Bhadraka, Mr. Nirmal, and Mr. Asel, thank you, all three of you, for wonderful sessions. I mean, we've had a little bit of time actually to inform you all and to get connected. But then again, you all managed within that short period of time to organize yourself and come into this platform and share your knowledge and your experience. So I believe we've had more time, but I think this is practical enough, so we don't run into more exaggeration of the topic. But still, for all, I just told you in the beginning, this is a series of webinars that we are going to conduct. So the part 2 or the next league would be coming very soon in the latter part of the month of May. So we'll see what would be our next topic, and hoping to meet all of you and more number of viewers expected in our next segment. And I once again, on behalf of IDM Nations Campus Management, thank all of you. And so we'll wind up the session from now on and see you all soon. Thank you very much. Good night.